Before we get started, we just want to thank Old Republic Surety for sponsoring this episode of Let's Get Surety, as well as NASBP virtual seminars. For more information on Old Republic Surety, visit www.orsurety.com. Now on to our show.
You're listening to Let's Get Surety. Let me hear your bonding talk with Kat Shamapande.
Hey everyone, it's Kat Shamapande. Thanks so much for joining us for this episode of Let's Get Surety. I'm excited. Today I've got with me my co-host, Mark McCallum. Hey Mark, thanks for being on.
Hi Kat, as always, glad to be here.
It's good to have you, and I'm excited for our topic. We're talking about some current trends and developments in terms of bid protests at the GAO.
Always an important and timely topic.
So to do that with us today, we've got Sarah Carpenter, and she's a partner at Smith Currie Oles. Hey, Sarah, thanks for being on.
Good afternoon. Happy to be here.
Well, before we dive in, Sarah, can you just tell me a little bit about Smith Currie Oles?
Absolutely. So at Smith Currie, we almost exclusively focus on government contracts and construction law. We have a nationwide presence. Currently, we have offices located in Florida, DC, the Carolinas, California, Seattle, and then Nashville, I believe. Personally, I started out in our DC office. My practice primarily consists of, the way I like to explain it, where construction law and government contracts overlap. So I deal with a lot of Contract Disputes Act claims. I also deal with claims at state projects on state procurements. Overall, I'd probably describe myself as a litigator. I usually have at least a trial or two a year, but I also really enjoy working with my clients on the project level. I've been project counsel before and enjoy advising clients on the project. So right now, I'm an equity partner at the Carolinas office for the firm.
Okay. So I know we're going to be talking about some key takeaways from the GAO's bid protest report to Congress for the fiscal year 2024. But before we do that, in case anyone doesn't know, what's the GAO?
The Government Accountability Office. And so the GAO is one of three forums where a bid protest can be brought, the other forums being the agency where the procurement is issued, but also the United States Court of Federal Claims. However, generally the GAO is the most popular forum for federal bid protests.
So before we get into the different pathways, for those who may be new to the industry, how would you define what a bid protest is?
Good basic question there. So a bid protest is going to be a challenge to a federal agency's procurement. And that could be a challenge either to where the contract has actually been awarded, or there can be a pre-award challenge to solicitation terms.
And what would some of the reasons be that somebody would make a bid protest?
Sure. So at the pre-award level, that's going to be a challenge to the terms of the solicitation itself. So for instance, if there's certain past performance obligations or requirements, and let's say that those requirements are not clear, and somebody notices that prior to the award, then that could be a grounds to protest. Or once an award has been made, the GAO report we're going to go into identifies the top three reasons for protests. But it often deals with how the agency is supposed to follow the procurement requirements and the procurement process and whether the agency did so properly.
So I know we're going to focus mostly on the GAO today, but I was curious if you could just enlighten us a little bit on what are some of the other features or differences between the other two forums that you mentioned earlier. So whether you go to an agency level protest or the Court of Federal Claims, I imagine there's probably some strategy that your clients need to think about before choosing one of these forums.
Absolutely. So there's going to be pros and cons to any of the forums, the GAO being the most popular venue. And I think that would be because it's a known commodity. And so it's also a streamlined process. It may be a little bit difficult to get into specifics because one of the unique things about bid protests is that there actually is a very strict process and some very strict timelines associated with bid protest. And that process and the timelines will vary depending on the venue that is ultimately chosen. And so I think that one of the pros of the GAO is that people are most familiar with the timelines and the protests there. So for instance, generally at the GAO, you have to file a protest within 10 days of knowing or should have known of the grounds for the protest.
Okay.
Whereas at the Court of Federal Claims, it is a more, some people may see it as a more cumbersome process, perhaps. It's going to be more akin to real litigation versus an administrative process. So you're going to have to file a notice before you ever even actually file the protest with the Court of Federal Claims. And whenever you seek a protest at the GAO, often the first form of relief that is provided is going to be a stay under SICA, which is the Competition and Contracting Act. And so what this stay does is it allows the protest to proceed and it puts the award on hold so that work doesn't begin being performed under the contract while the protest plays out. One of the key differences at the Court of Federal Claims, for instance, is you would have to meet the requirements for essentially a preliminary injunction to get a similar stay. And so I think that the difference between obtaining a preliminary injunction and the ability to get that SICA stay is probably one of the main reasons for choosing a different forum.
So it's a pretty high bar to get a preliminary injunction then?
You have to show that you're likely to succeed on the merits of the case.
Okay.
So I think it can be done in similar circumstances. I do think it's, can be a more cumbersome process and perhaps more difficult because the SICA stay is kind of a default almost. And so the agency really has to come up with a reason, such as maybe performing under the contract is required for national defense reasons, and they can't really afford to just put it on hold. But unless there's a really compelling reason, the SICA stay is more of a default that you're going to get.
So you've touched on some forms of relief. Now, are there also differences between the two forms? For example, does one allow you to receive damages and one does not? Or are there other substantive differences on why you would choose GAO or the Court of Federal Claims?
Not necessarily we mentioned the differences in the kinds of stays, but at either the Court of Federal Claims or the GAO, for instance, the forms of relief that are generally available are going to be, for instance, a corrective action. And so this is actually something really important that a lot of people that are unfamiliar may not necessarily understand about a bid protest. Just because you win a protest or your protest is sustained, it doesn't mean you're going to win the award. All that a bid protest, winning a protest means is that the protester gets the ability to compete fairly with everyone else. And so the relief that may be provided either at the Court of Federal Claims or the GAO level could be just telling the agency to go back and redo their analysis because you didn't do it right the first time. It could be that provision in the solicitation was not very clear. So you need to amend the solicitation and then have the offerors submit new bids and then do your analysis again. So that's going to be relief that is available at the Court of Federal Claims or the GAO.
Okay, great. And you were saying one is more formal than the other. So the Court of Federal Claims, more formal, much like litigation, not so much with GAO.
Very much so. So there's rules of civil procedure that apply at the Court of Federal Claims. It is going to be more of your standard litigation and the standard litigation process that you see on other federal courts. Whereas the GAO is more of a administrative process. So you don't have, the rules of civil procedure to follow. And the filing is going to be done a little bit differently. So I would say it's a less formal process at the GAO.
So these are all factors that a client if they're being motivated by time and cost, they need to account for these based on advice of counsel on which direction to take. Is that correct?
Absolutely. And I hate to sound too much like a lawyer, but I feel with bid protests, it is particularly important for the client to get attorneys involved early and get attorneys involved who are knowledgeable with this specific area of the law. Whether it's to advise on the forum, to advise whether a bid protest is actually going to be, good grounds for spending your money. Because like I said,
Right.
just because you protest doesn't mean you win the contract. So you're just winning the opportunity to continue to compete with the other bidders.
So a good attorney with experience can help them assess if that's a valuable way to spend their time and money.
Exactly. And in addition, one of the things that's unique about a bid protest that's different than a lot of other litigation is there's what's called protected information. And so you reach a certain point in the process where the protester, the actual client, does not get to review all of the documents and information that is being provided as a part of the protest. And so that's another reason why the client really wants to find an attorney who's knowledgeable and who they're going to trust, because the client isn't going to have eyes on everything the attorney does. And at a certain point, just has to trust the attorney's analysis.
Well, it sounds like the client would be at a severe disadvantage by not having counsel and not having someone on their side looking at that information. So,
I would absolutely agree with that. I think that technically a client is permitted to proceed with a bid protest without counsel. But the downside to that is that the client would not be able to view the protected information, even if, they don't have counsel. And so that would be a huge handicap in proceeding in any protest.
Wow. Well, you said earlier that the GAO route was the number one choice. Could you go a little bit more into that? I know we've hit a number of things, but for example, are there certain trends that you're seeing over the last couple of years with parties availing themselves of the GAO? And what kind of success rate do parties have in that forum?
Absolutely. And so that kind of gets to the GAO's annual protest and the annual report that is provided to Congress every year.
Yep.
So the GAO provides this report to Congress pursuant to SICA, what we previously mentioned. And essentially, the GAO is required to report certain statistics regarding the prior year, such as an effectiveness rate, a sustained rate, and also a unique little feature where the GAO actually isn't really the final decision maker whenever it comes to a protest. It issues a recommendation to the agency. So, hey, agency, we didn't think you got this quite right. We think you need to go back and redo it. Technically, the agency could decline to follow the GAO's recommendations. It happens almost never, very rarely. In the 2024 report, the GAO said that there was just a single case where the agency did not follow its recommendation.
Wow.
But if we look at some of the statistics, it's important to know kind of what the different statistics are. And so I think you talked about success rate, but at the GAO, there's something called a sustain rate, and then there's something called an effectiveness rate. So a sustain rate is going to be the rate where the GAO actually sustained the protest, so agreed with the protester in whole or part. That rate, the last several years, is usually hovering, I would say, around 15% the last several years. And you may think, oh, well, that seems low. But that's because the sustain rate isn't really capturing what is often going on in these bid protests.
Okay.
So that's why most often people are going to focus on the effectiveness rate.
Okay.
So what the effectiveness rate does is it captures not only the cases where the GAO sustained a protest, but also where voluntary action, corrective action was taken by the agency. So the protest gets filed and the agency says, okay, we will go back and do XYZ differently. And they agree to do that on their own. And that's where you get the effectiveness rate, which the last several years has been hovering around 50%. And I think that speaks volumes for potential bid protesters.
You're a baseball player, you're going to the Hall of Fame if you're batting 50%. So Yeah, yeah, I like to hear that. And so that really gets to the client's needs in many regards, right? Because if they're all of a sudden now the solicitation is clarified or some other action is taken, so as you said, to put them on a basis to fairly compete, and that's their interest in the first place, right?
Absolutely. That 50% effectiveness rate, I think it speaks to first clients obtaining that kind of good counsel that we talked about so that they're not wasting their money. And so, hopefully it appears they've received the advice that they need and they're really
Yeah.
protesting where they have a good chance of obtaining some kind of success. And then it's good for everybody, the government and protesters alike, because what that says is that fair competition is being ensured there.
So you mentioned the effectiveness rate and the sustained rate. Do they also include information on how many bid protests come through the GAO in a given year?
Absolutely. So one of the trends that we see with the annual GAO report is that bid protests have continued, the number of bid protests pursued has continued to decrease. There is this, anybody who actually looks at the GAO reports, there's a caveat to the 2023 numbers, just so everyone knows. They're a bit of an anomaly. There was this one procurement that resulted in, I think, hundreds of protests for that one procurement. And so it really skewed the numbers for 2023. But if you take a look at the last 5 years minus 2023, you're going to see that there's anywhere from, let's say, 1,800 to 2,200 bid protests that are filed a year. And we're generally seeing a little bit of a decrease every year in the number of protests that are filed, which some people see as good news. That means that the agencies are following, rules and regulations and doing what they're supposed to do.
That is good news if that's the case. So you had earlier alluded to that the GAO has identified the most prevalent grounds for sustaining protests. Could you tell us a little bit more about what those are?
Absolutely. So the GAO, this is another one of those benchmarks that the GAO reports as part of its annual report every single year, is the three most prevalent grounds for which a protest is going to be sustained. And so these three top grounds, they've been the same the last couple of years, so they're fairly common. This past year for 2024, the three grounds were unreasonable technical evaluation, flawed selection decision, and unreasonable cost or price evaluation.
Okay. And you mentioned that the sustained rates are in there, and those are the top reasons that they're sustained, the bid protests.
That's correct. Sorry, for 2024, the sustained rate was 16%.
Yeah. Oh, it was 16% in 2024. And how does that compare, over time?
So the sustained rate for the last 5 years has hovered right around 15%.
Okay.
So that's fairly standard for 2024. And the top grounds for sustaining the protest tend to be the same as well. Okay. Of course, they're broad grounds. They encompass a lot of different things.
How does understanding these numbers help a client out? And what can they kind of take away from this report and the numbers we're seeing, the consistent decrease in bid protests and the same level pretty much of the sustained rate? What's the takeaway from that, or the trend that we can find there?
I believe that the takeaway is that the process is providing value to contractors, and that value is to ensure that there is the ability to compete. So taking on the cost and process that going through a bid protest is something a client definitely wants to look at and weigh. It's not, we never want for a client to throw money at something that there's not great success at. But what we see by these numbers kind of remaining the same is that when bid protests are pursued, the process appears to be working and that clients are obtaining relief around 50% of the time.
And I guess I didn't ask this earlier, but I'm curious. So when we see these numbers on the bid protest, that includes all procurements, not just construction procurements. Is that correct?
That is correct. For the GAO, that is going to be all federal procurements. If there are procurements at the state level, then that is not going to be included in any of these federal procurement numbers that we're talking about at the GAO or the Court of Federal Claims.
And they don't break it down between whether it's construction related or non-construction related in terms of the federal procurement protest, right?
I'm not really sure. I would have to go back to the GAO annual report, but I don't believe that that was a statistic that was provided in their annual report.
Yeah. I was wondering, you mentioned earlier about the importance of getting that clarity in a pre-award protest. Could you go in a little bit about post-award protest and what are some of the reasons behind the desirability of doing that for a client?
Sure. So I think you're talking about the topic that we already kind of touched on was some of the top reasons why bid protests are often pursued and often successful, right?
Yep.
So one of the grounds that the GAO identified was unreasonable technical evaluation. And what the GAO does is every single year, they'll list these top grounds and they'll actually provide an example case.
Oh, okay.
So that you get a good idea of what they're talking about when they say unreasonable technical evaluation. So this year they provided the example Kaufman and Associates, which was a case where the decision came out in January of 2024. It was a post-award protest involving a procurement for DHS. And actually, the protester protested on several grounds, all of which were sustained. And so the procurement at issue was a best value quote, and there were 5 technical factors that were supposed to be weighed equally. And the protester essentially said each of these 5 factors were not properly evaluated and weighed by the agency. The GAO all agreed with the protester on all 5 grounds. And so one of the examples was that one of the factors was a management plan, and the management plan had to include how the offeror intended to protect certain confidential and privileged sensitive data. And the awardee did not include that information in their bid. And so the agency tried to say, oh, that was a harmless omission. And the GAO said, no, that was a factor that you were supposed to consider, and it wasn't in their bid, so how could you possibly consider it? The other thing that I think really came through on this unreasonable technical evaluation factor was the agency's record was not sufficient. So there's going to be an administrative record that any bid protest is decided upon. And GAO gets to go and look through the documents and see what the agency did or did not do. And they said, well, the protester says you guys didn't do X, Y, Z. And if you did, you sure didn't document it. And so that was another one of the reasons why that protester ended up being successful. Ultimately, the agency was told to go back and do a proper evaluation. And the protester was awarded fees and costs as well.
Wow. Yeah, very interesting illustration. So is it similar to the other two, the flawed selection decision, in terms of they're evaluating the agency's kind of process and then deciding whether or not they adhere to their own rules and practices?
Exactly. And the agency doesn't get to redo the agency's analysis and question every single thing that the agency did. They're looking to make sure that the agency did what they were supposed to do and were reasonable in doing so. And so, for instance, one of the other common sustained grounds is an unreasonable cost or price evaluation. So where an agency is supposed to do an evaluation, a price evaluation, it's supposed to be a price realism evaluation. And what the GAO points to is that doesn't mean that the agency just says, okay, here's the prices, low, high, they make sense, and they go with the lowest price. There also has to be a feasibility or a technical evaluation that that ties into that price evaluation.
Okay.
Is the technical approach that's being proposed for that price reasonable? And that's ultimately one of the reasons, that was one of the top reasons for sustaining a protest at the GAO in 2024.
That makes sense. Well, are there any other key takeaways from this or advice you want to give around bid protest with the GAO?
I guess nothing I haven't already said before. I think it's just really important for contractors to know that a bid protest can be a very powerful tool to ensure fair competition, but it's not something that you want to jump into feet first. Definitely wants to evaluate the potential cost of a bid protest and what relief is realistically going to be provided.
And you said earlier the importance of hiring a knowledgeable legal counsel and involving them early,
Hmm.
particularly for our members who are the bond producers who are trying to help with resources to their construction clients. What would you say would be the best way to evaluate the right counsel to help in a situation like this?
I would say that generally counsel who do bid protests, it's going to be a niche area. So it's going to
Okay.
be something
Yeah.
that the attorney will advertise this, as something that they do. If a attorney says they do just government contracts or construction law, that is a very different world. Bid protest is a very specific process. So I would recommend looking for an attorney who has a track record of specifically performing bid protests.
Great advice. Thanks so much.
Yeah. Well, thanks, Sarah, so much for being on with us today and talking a little bit about bid protest and the information we can get from the GAO's report to Congress from 2024. It's been great having you on.
You've been listening to Let's Get Surety, brought to you by the National Association of Surety Bond Producers. For more information about the NASBP and its members, visit nasbp.org.
Before we go, we just want to say thank you again to Old Republic Surety for their generous support in sponsoring this episode of Let's Get Surety. For more information on Old Republic Surety, visit www.orsurety.com.